Good morning, everyone. Thank you for joining today's Trust and Estate Controversy virtual forum called Nobody Likes a Killer, Slayer Statutes and Wrongful Death, Civil Murder Statutes Make Certain Crime Doesn't Pay, which we thought was an appropriate topic for the week of Halloween. My name's Peter Allport. I'm a partner here at McDermott, Will & Emery and a member of the Trust and Estate Controversy team, and I will be moderating today's panel. And I am joined today by my partners, David Baker, who is the head of the Trust and Estates Controversy team, and Lisa Linsky, who is in our litigation group and also a member of the Trust and Estates Controversy team, and Margaret Sanney, who is in our private client group and is also a member of the Trust and Estate Controversy team. And before we dive into the presentation, I just wanted to address a couple preliminary matters. First, if you see at the bottom of your screen, there's a Q&A button. Questions can be submitted through that Q&A function, but we will probably address questions at the end of the presentation. After the presentation, we will circulate a PowerPoint deck that will contain most of the information that is discussed today. And finally, if you're requesting CLE credit in New York, please listen at the end of our presentation for a validation code that's needed to obtain the CLE credit. So with that, let's dive into our program. And Dave, what is civil murder?
So for those of you who are old enough to have been glued to a television 26 years ago in 1994, you may remember that football star and broadcasting personality O.J. Simpson was charged and tried with the murder of his ex-wife Nicole and her then friend Ron Goldman. He was acquitted, but shortly after that, the family members of Nicole Simpson and Ron Goldman filed a civil action in California courts under wrongful death and succeeded in getting a verdict that essentially wiped out Simpson financially. And if you are wondering how or why that happens, that's what we're going to talk about today. The who and why and how and what impact it has, because interestingly, those cases often happen in, of all places, the state probate courts. And there's a reason for that. So unlike criminal law, which has the consequence of incarcerating or even occasionally putting to death the perps, to kind of prevent and provide retribution for crime. Civil murder is a private action between individuals who are suing, usually to accomplish one of two things, but both are designed to essentially keep the perpetrators of a killing from benefiting financially. The old crime doesn't pay modem. And the reason we're doing this, or one of the reasons we're doing this, is these civil murder laws only have force and effect if everybody knows they're out there, because the main purpose of these is to get the word out that there is no potential financial benefit from killing somebody or causing somebody's death, and therefore don't do it, don't bother. So there are two kinds. Wrongful death and so-called slayer statutes. They differ primarily in the remedies that are available. A wrongful death is suing the person who caused the death to get financial damages for the people who are dependent on the decedent, and we'll talk in greater detail about what that dependency means. Slayer statutes, on the other hand, are designed to block any sort of inheritance or recovery of money coming from the deceased person to the killer. And again, we'll talk in greater detail about what different forms of inheritance and other property devolution are blocked by slayer statutes, but that's the main difference. So wrongful death is a little broader in its application because it typically can apply to anybody who's caused a death, regardless of whether or not the person they killed had any money from which to inherit. As will become kind of apparent, Slayer statutes are most commonly invoked between spouses and children and parents, because those are usually the people from whom you're going to inherit if somebody happens to die. So wrongful death is a creation of statute, excuse me, a common law. If you did something bad to somebody and you injured them, you could get hit with damages. But if you killed them, you were off the hook. There was no such thing as a common law as wrongful death. That seemed to a lot of people to be a really bad idea. It effectively kind of put a bounty on injuring people, because you were better off if you injured them so seriously that they died than if you just injured them badly enough that they were alive but hurt. This all really comes about from our New York legislators, who were getting on the Long Island Railroad, because at the time the Long Island Railroad was designing its rail cars in such a way, its passenger cars in such a way, so that if there was an accident, the riders were much more likely to get killed than injured, because that was a better deal for the railroad. And the legislature decided in New York that that was a bad idea. So wrongful death began there and pretty much spread across the country. Margaret, why don't you talk about how that works?
So to get rid of that bounty Dave described, and to disincentivize people and entities like the railroads from going for broke in these accidents, state legislatures enacted wrongful death statutes as a means to punish criminal and non-criminal death causers, if you will, with civil liability for damages. And at the same time, you started to see states update their existing laws so that personal injury claims were not extinguished by virtue of somebody's death. So as a result, if a victim dies in an accident, you'll often see a personal injury claim and a wrongful death action filed at the same time. Now, if the person dies instantaneously, then typically a personal injury claim is not going to lie. Pain and suffering is difficult to prove with an instantaneous death. And so in those cases, you'll just see a wrongful death action, but typically you see the two filed together. So the key distinction between wrongful death and personal injury claims is who owns each claims. That is, who benefits from the recovery. A personal injury claim is owned by the decedent, by the decedent's estate. And so the victim's estate is going to benefit from any recovery on that claim. On the other hand, wrongful death actions were created to compensate the victim's survivors for the death. So wrongful death actions actually belong to the survivors. Any recovery there is going to benefit the survivors of the victim. The distinction itself is critical for tax purposes. So because the personal injury recovery belongs to the estate and to the decedent, it's actually included in the estate for estate tax purposes. Wrongful death awards are not. They belong to the decedent's survivors, so they escape any estate tax. Both awards are excluded as income for income tax purposes. So the focus here is really just on the estate tax. So as a result, allocation of damages in settlement negotiations is a big deal, particularly when you're dealing with a taxable estate. And you'll want to consider how much is being allocated to personal injury and how much is being allocated to wrongful death. Insurance companies tend to lump the two recoveries together, but litigants should not, especially when dealing with a taxable estate. Now, keep in mind, the IRS is not necessarily bound by the allocation of damages in a settlement agreement. And not surprisingly, settlement agreements that heavily weight damages in favor of wrongful death, as opposed to pain and suffering, will receive heightened scrutiny by the IRS. And the IRS has been known to reallocate damages in cases it feels that the allocation was just designed to avoid the estate tax.
Dave, Margaret mentioned survivors. Who qualifies as a survivor?
So we'll get into that in greater detail, but essentially, and this differs state to state, but essentially, it's a dependency determination that the trial court makes, the same trial court that is hearing the wrongful death case. And in most states, that's a financial dependency. So spouses and minor children are always going to be dependents in virtually every state. There are other ways that people who are not spouses and minor children can be dependent. You can have a disabled adult child that you're supporting. You can have a distant relative or a parent that you're supporting. And in some states, those sorts of tangential means of support will be disregarded. In others, they are allowed in the determination. Generally speaking, a plaintiff's lawyer's appetite for taking a wrongful death case is going to turn very much on who's around, because however horrendous the cause of death may be, the recovery is actually going to be more affected by the degree of survivorship than actually by the nature of the wrongdoing that brought about the killing. One thing I want to just point out about what Margaret just said on settlements, very often these cases are not handled by tax lawyers. They're usually handled by litigators who may have very little background in the tax consequences of what they're doing. The defendants and their insurance companies don't really care how you allocate it. They just want a release from everybody. Doesn't really change the size of their check that they're writing. And so often there isn't a lot of attention paid to the tax consequences when there's a settlement. If there's a trial, you're going to get an actual judicial determination of how much of the damage results from the injury and how much of the damage results from the actual death and survivorship claim. In a settlement, you don't have that more often than not. So it's important to make sure that before these cases settle, if they're going to settle, that somebody who understands the tax consequences sort of pokes their head into the room and makes some noise about how the proceeds are going to be allocated. Because very often there isn't a definitive answer on how they ought to be allocated. And the payors, the defendants and their insurance companies, don't care. So as a practical matter, that's an important thing to keep in mind. I said that these things often go forward in probate courts. The reason for that is that the Slayer statute piece of these things, which Lisa Linsky will get into in greater detail in a moment, the Slayer statute part of these things is typically part of the State Probate Act. It is a statutory provision under the probate code that changes the degree of inheritance and disinheritance. So very often the wrongful death case is tied in as a pertinent case with that. And oftentimes it's happening in, of all places, the probate court. That's basically how the survivorship determination works. It's a facts and circumstances case. Once you get past spouses and minor children, as a practical matter, there are some states. This is getting changed as we speak in a few jurisdictions, but there are some states that actually allow this dependency determination that drives wrongful death recovery on an emotional dependence or loss of consortium. In other words, a non-financial dependent relationship. For obvious reasons, a lot of courts and a lot of insurance companies have a great deal of difficulty with this because they think it's a little too ishy-squishy to be the subject of a damage award. And there are states that have actually by statute taken away the loss of consortium claim. But the important thing to keep in mind here, and we'll talk about the practical consequence of this in a minute, the determination of who is a dependent is actually made by the court that is hearing the wrongful death case. So because that's the case, when the whole thing starts, nobody really knows who's going to be the dependents. And you can't file the lawsuit because you think you're going to be a dependent as a plaintiff. So in all of the states that allow wrongful death, and that's now all 50, the person entitled to bring the case initially as plaintiff is the executor of the decedent's estate, the representative of the estate. this confuses the heck out of people because they assume that because the executor or personal representative is the plaintiff, that means the wrongful death recovery is an estate asset. It's not. The representative is a nominal plaintiff, basically there as a placeholder until the court makes the determination of who the real plaintiffs are, which are the dependents who get the recovery. And even in an estate where there is no representative because there's no probate assets and no other reason to open an estate, a representative can get appointed simply for the reason of pursuing a wrongful death case. And if that hasn't happened, the law courts, which may, in those cases, will hear the wrongful death case instead of the probate courts, have the ability to appoint a special representative to be the plaintiff in the wrongful death case. But keep in mind also that the representative is the true owner from a property law standpoint of any survivorship claim for personal injury. So you were injured. If you hadn't died, there would be a damage award because of all the consequences, the pain and suffering, the rehabilitation and other things that could flow from the damage case. That case is also owned by the executor and is actually owned by the executor as an estate asset. So when there's a wrongful death case and it's not an instantaneous death, typically the executor is serving two functions. He or she is the stand-in nominal plaintiff to represent the future beneficiaries of the wrongful death based on dependency. And that person is also the actual owner of whatever claim there is to personal injury, which will become an estate asset. Again, as you can see, it's the kind of thing that confuses the heck out of parties and courts and insurance companies, but that is the way it works.
So, and Margaret, in cases where there are no direct dependents, are there still times where wrongful death claims are filed?
Yes. So wrongful death claims can be used for a couple different reasons. One, it's the only civil remedy available for victims who don't have money. And I'll let Lisa get into the Slayer statutes, but it can also be used as a way to push forward or jumpstart a stalled or non-existent criminal investigation or prosecution for murder. And Lisa will get into the burden of proof here, but in many cases, the authorities may begin their investigations by examining a record established at trial in a civil case. And with that, I will turn things over to Lisa.
Thank you, Margaret. Good afternoon, everyone. Good morning. I was really thrilled when Dave and Margaret reached out to me to do this program with them because I'm a former prosecutor and I actually handled homicide cases. I ran a special prosecutions division where we focused on child abuse, domestic violence, sex crimes, and family-related homicides, including high-profile murder cases. And I did that work for over 15 years, and I can tell you there was nothing ishy-squishy about it. I learned a new term today, Dave. Thank you. It's fascinating to me, even now, having been away from criminal work and criminal prosecution work for so long, but it's still fascinating to me as a civil litigator, why people kill. And why people kill their supposed loved ones. And yet it happens all the time. And money is oftentimes the motivation. A couple of just high profile examples to give you, and I won't get into them in too much detail, but they are just so interesting to talk about. You remember the Menendez brothers back in the late 80s who killed their parents because the boys learned that their father was going to disinherit them. So they killed them. They killed their parents while they still were in the will. A case that certainly captured my attention when it was happening was the Scott Peterson case out of California. Scott Peterson, you may recall, was the young man who murdered his wife and unborn son. And just before, about a year before their murders, he had taken out a life insurance policy on his wife. His life was a mess at the time of the murders. He was involved in an affair. He was very stressed about becoming a father, and he was in significant debt. He was subsequently convicted of both murders in California, and the California Slayer statute kicked in when Scott tried, despite the murder convictions and a death penalty sentence, to collect on the insurance policy. It was about $250,000. He thought he should get the money from Lacey's policy, where he was named as the beneficiary. And of course, the California Slayer statute prevented that from happening. We've had some very high-profile cases involving money and murder in this part of the world, New York and Connecticut recently. One case, Rod Coleman, this was a New York City case. He was convicted of murdering his estranged wife, who was a very successful banker. It was a high-profile case. Crime actually happened back in 2009, and it took years of investigation to finally bring him to justice. He was convicted last year, and his motive was her estate, which was over $5 million. And she was getting ready to cut him out of her will as well. What's so interesting about these cases, and really harkens back to Dave's opening point about the need to raise awareness about these statutes and these remedies that are available when killers kill, available, that is, to the other beneficiaries and folks who should inherit, is that these killers commit the crimes because they think they're going to get the money, the inheritance, the life insurance proceeds. And yet by committing these crimes in virtually all states, they're shooting themselves in the foot, literally, because they can't get to the money. So it's very, very interesting. Anyway, Slayer statutes, you've heard us reference them. I want to talk about them briefly and try to distinguish them for you, because while the underlying rationale to these Slayer statutes is pretty much all the same, crime shouldn't pay, a killer should not be able to profit from his crimes or be unjustly enriched by his crimes, the statutes state to state are different. And I'm going to talk about that in just a moment. But as a general working definition, Slayer statutes provide a right of a civil action to the victim's successors, representatives, and other interested parties who want to prevent the killer, and I'll use that term in the broadest of senses, the killer from inheriting money as a result of his or her crime. And that's what we mean by the Slayer statutes. There's a core public policy consideration that underscores these Slayer statutes. Now, the first time that this notion was recognized as a legal principle came in the late 1800s in an 1886 case called Mutual Life Insurance v. Armstrong, where the United States Supreme Court determined that a man who was convicted of murdering his business partner could not receive the proceeds of an insurance policy he had taken out on his business partner. So Slayer rules and statutes vary in some key ways. One is the source of the rule. As Dave mentioned earlier, some of these Slayer statutes are found in the various probate codes of the states. Others are found in insurance law. And frankly, for most of them, you do need to look at the criminal statutes and understand what the predicate killing crimes are that are often taken into account before you can even get to the civil statutes. So that's one way they differ. They differ with respect to the degree of the crime that may trigger a Slayer statute. Typically, yes, murder would be included because murder is generally considered an intentional killing. It's a mens rea of intending to cause a particular result by acting in a certain way that results in the death of the decedent, of the victim. But there's also the act, and it's not always as clear cut as, well, it's an intentional act. An intentional act can mean a number of things, including murder, but not necessarily murder, which I'll explain shortly. Whether or not a conviction is actually required. In some states, like Illinois, for example, the proceedings, the criminal proceeding and the civil proceeding under which a Slayer statute is invoked can be distinct proceedings. And yet other states, which I'll mention in a moment, other states actually require a criminal conviction. Most states, on the other hand, treat a criminal conviction as a presumption, so that in the civil litigation, if there had been a criminal conviction, it's a presumption that the killer has been designated for legal purposes as having committed an intentional, felonious killing of the victim, and therefore is precluded from collecting the inheritance or insurance proceeds, whatever that may be. And then, of course, two other considerations that distinguish these various Slayer statutes: the nature and extent of the various property rights that are forfeited. Generally, the statutes are quite broad and can include not only things that one would inherit under, say, a will or trust, or even the intestacy laws, but also things like insurance proceeds, funds from a pensioned account, things of that nature. Generally, but not always, very broad. But again, I can't stress enough, the language of these statutes is critical, because there are nuances that govern each state's particular rules that need to be paid attention to. And the last distinction, if you will, is whether or not alternative takers can actually take or receive the assets from the victim if they are related to the slayer. Some states, for example, like Maryland, will not let anyone take because of their Slayer statute, because if they are somehow inheriting through the killer, then the Slayer statute's going to prevent that type of unjust enrichment. Most Slayer statutes are codified, but not all of them. So New York, for example, is a state where to this day they rely on common law. And the leading case in New York was decided back in the late 1800s as well. It was called Riggs v. Palmer. And it was the first time that the Court of Appeals of New York found that the quote, the tenets of universal law and maxims would be violated by allowing this man Palmer to profit from his crime. So that was a very early example of the public policy consideration that you can't let a person benefit from his or her own wrongdoing. One of the things I found very interesting in preparing for today's discussion was there really is relatively current litigation involving these Slayer statutes. This is not some archaic concept that sits up on a shelf. There are real life situations where these issues occur, and they occur in real time, if you will. Let me also mention that Missouri is another state where the common law rules. There's no statutory Slayer statute. Maryland was a little bit late to the game in that they too followed common law until about 2015. And now they have a very, very strict Slayer statute. The types of conduct that can trigger a Slayer statute application in Maryland, for example, felonious and intentional killing. Most of the Slayer statutes require some kind of intentional act that results in the death of the victim decedent. But Maryland's a little bit broader. So they also include conspiring to kill as well as procuring the killing. So you may have a situation where the killer is not actually the beneficiary, the person who was seeking the money. Perhaps the killer is a hired gun. And the person who's seeking to benefit from the estate never got his hands dirty, you might say, right? Doesn't matter in a state like Connecticut. Many other states couch it a little bit differently. They'll say that if the slayer is a principal, the Slayer statute may be triggered. But if the slayer is an accomplice, and again, never pulling the trigger himself or herself, then that person may well also be precluded from taking under the estate. I mentioned in passing New Hampshire because New Hampshire is an example of a state where they don't have a Slayer statute, very unusual. And they generally don't follow the common law. So New Hampshire has created a legal fiction in these cases where someone has killed another person and a family or a state representative is trying to make sure that the slayer doesn't get the proceeds of the estate. And what New Hampshire does is they set up something called a constructive trust. It's a legal fiction and something of an equitable remedy in that there's not an actual trustee, but the purpose of it is so that the court can order that any property that would otherwise pass to the bad guy, to the slayer, has to be transferred to the intended parties or the rightful beneficiary. So New Hampshire is unusual in that way. I'll mention just a couple other states to underscore the distinctions that I'm talking about and the reasons why language is so important, and you have to really look carefully at the state slayer statutes and, as I mentioned earlier, many of their related criminal statutes, because Connecticut, for example, is a state where they have a slayer statute where someone can be precluded from inheriting, whether they acted as a principal or an accessory. But there are certain predicate crimes that are delineated in the Connecticut slayer statute that need you to reference or cross-reference their penal law. So, for example, they mention murder in the first degree, murder in the second degree, but not manslaughter. And for anyone who's not sure of the distinctions, obviously murder is an intentional act. You intend to cause the death of another person, and you do so whether intentionally or by conscious disregard or a reckless type of behavior that is different from intentional, but at the same time rises to the level of an intentional crime. But Connecticut doesn't recognize manslaughter, which is a lesser crime in most instances. Whereas if you look at Massachusetts, on the other hand, you need to look at their penal law as well, and only if there's a conviction for murder 1, murder 2, or manslaughter. So while Connecticut excludes manslaughter, Massachusetts includes manslaughter. So just another example of why you need to look at the language. Also point out that in the Connecticut slayer statute, if there is no criminal conviction, I'm going to address this in a little bit more detail in a moment. If there's no criminal conviction, a court of competent jurisdiction can still make a determination, that is a civil determination, as to whether or not a beneficiary should be barred, but barred from taking life insurance proceeds. So it's much narrower, a civil remedy, if you will, under the Connecticut law. Massachusetts is even a little bit more quirky in that if there is a criminal case and the defendant is acquitted of the homicide, meaning murder 1, murder 2, or manslaughter, if that person is acquitted, that defendant is acquitted, he is not barred from taking under the estate. So again, real nuances here. Florida is another interesting example, although Florida says that if there is not a criminal conviction, that's okay. You can have a separate civil action with a court of competent jurisdiction determining whether by the greater weight of the evidence, which is a preponderance of the evidence standard or burden of proof, if the killing was unlawful and intentional. One of the other things you should be aware of is the language that triggers these slayer statutes and rules. While intentional is pretty much a common denominator among these statutes, there are some distinctions. For example, the Uniform Probate Code talks about felonious or intentional killings. Some states talk about willful killings. Others talk about unlawful killings. And you have to dig into some of the case law to figure out what that all really means. I mentioned the burden of proof, and a key distinction here is that because these slayer statute types of litigations are civil in nature, the burden of proof is what we call preponderance of the evidence. It's the lowest, least stringent, if you will, burden of proof. What does it actually mean? That's more likely than not, meaning it could be like 51%. Now, as a former criminal prosecutor, I can tell you that beyond a reasonable doubt is the most stringent burden of proof that a lawyer has under the law. And you have to establish to a trier of fact satisfaction that there is not a doubt to which a reason can be attached. And I won't get into it too much more than that for now, but suffice it to say that it's tough. I tried a lot of criminal cases, including homicides, and it can be very difficult, particularly in a domestic situation where the parties are in a family or intimate relationship. Okay, wanted to mention a distinction here, and then I'll talk about two other topics that I think are interesting to this whole conversation, and then turn it back to my co-panelists. One is there are other laws across the country that are similar to Slayer statutes, but distinguishable. And I'm sure you've all heard of them. They're known as the Son of Sam laws. And this was a law that New York first enacted in 1977 after David Berkowitz, a serial killer who killed numerous people in New York City and Yonkers in Westchester, New York, after he confessed to these murders, ostensibly referring to Sam, who was his neighbor, and Sam's dog, who told him that he was to go out and kill these people. P.S. Berkowitz later admitted that was a hoax, but the name still stuck, the Son of Sam killer. And the concept behind the Son of Sam laws is a little bit distinct from the Slayer statutes. The idea behind the Son of Sam laws is that a killer cannot profit from selling his story. So, for example, if there's a book deal or a movie deal, and the person selling the rights to his story is going to be compensated for doing so, then victims of the family members, estate representatives, etc., can go after those proceeds. And the state actually will come in upon the filing of a petition by an interested person. State will come in and freeze those assets so that the killer cannot get access to them. The Son of Sam laws, by the way, were adopted by, if not every, then virtually every state in the country using the New York template. And what I will also mention is the Son of Sam laws are broader than the Slayer statutes insofar as you don't need the same predicate crimes that you typically see in connection with a Slayer statute. With the Slayer statutes, even forgetting that there's a criminal case, maybe there isn't a criminal case, maybe the prosecution doesn't feel they have sufficient evidence to prove the intentional killing beyond a reasonable doubt. That doesn't necessarily preclude the civil Slayer litigation because of this lesser burden of proof. If a court determines that there was an intentional killing, whatever that means under that state's law, that's sufficient to block the inheritance. But under Son of Sam, you don't need those predicate crimes. In other words, it can be any felony. And in that respect, the Son of Sam laws are further distinguished and also broader. Last two things I want to mention to you. Again, I talked about whether or not a criminal conviction is a prerequisite to a civil litigation involving these issues. Short answer is not necessarily. Again, it depends on the laws of the given states. But here's something that I thought was really fascinating, and I hadn't really thought about it until we started preparing for our panel. And that's really two issues. So one is, well, what happens if there is a criminal prosecution and it results in an acquittal as a result of a valid self-defense claim? Now, self-defense in most states is an affirmative defense, meaning the defendant has the burden to establish that he or she was acting in self-defense. And that's the real short version of that story. Self-defense defenses are very complicated, very fact-specific, and also very jurisdiction-specific. There are only certain times, for example, that someone can use deadly physical force that results in the death of a person. But let's assume a case where we have deadly physical force, all right? Someone is dead. And if that victim was one who included the killer in her estate, well, guess what? We now have a situation where how can this person be allowed to inherit under these circumstances? Does the self-defense, in other words, remove the unjustified or justification, the unjustification for the killing? So you may have an intentional killing, but if that intentional killing is justified under a defense of self-defense, then many states say no dice for the Slayer statutes. So again, you have to look at each of those statutes. The last thing I want to mention to you, which to me, we could spend an entire panel presentation talking about this topic. I handle many, many of these cases as a DA, and these are cases where the slayer is insane, is either found not responsible by reason of insanity or not responsible by reason of a mental disease or defect. It could be in the context of a criminal case where the slayer is convicted but found not responsible, or enters a guilty plea, which is also a conviction, and found not responsible. And as I said earlier, you don't necessarily need a criminal conviction. So is an insane killer permitted to take? It depends. So let's see what Maryland says. Maryland says, well, maybe not. Under Maryland, it turns really on whether at the time of the killing, the killing itself is determined to be felonious. If it's not felonious, that is, if it's justified, the killer is going to be allowed to inherit. Washington State, on the other hand, has taken a different approach. In a case called Estate v. Kissinger, the court held that a son who had murdered his mother was not entitled to share under the proceeds of a settlement with the mental health agency that basically screwed up and didn't monitor the son who had a long history of mental illness. The court felt that it just wasn't right to let this son partake in the settlement. That was Washington State. In South Dakota, only sane killers can be prohibited from taking under the social services law. Indiana used to apply that type of rule, where if a killer was found to be insane, then he was not precluded under that state's Slayer rules. But subsequently, the Indiana legislature said, you know, something's wrong here. That's not right. And they changed their law. The last thing I want to leave you with is just a couple of takeaways from the Uniform Probate Code. And basically the Uniform Probate Code, which some states follow and others take variations of it, says that the killer must forfeit all benefits under a victim's estate when the killer feloniously and intentionally kills. In other words, under the UPC, the killing cannot be accidental. You can't have a vehicular homicide, for example, unless you can show it was intentional, and then it's just a lesser included offense of a murder. But if you have any kind of, for example, criminally negligent homicide under the UPC, that's not going to carry the day for the Slayer statutes. The other thing that the UPC raises, and some cases have also, some statutes rather in the states also incorporated, but not all, is this notion that, well, okay, when is a criminal conviction final for purposes of triggering the Slayer statutes? And the answer to that, again, is it depends, but under the UPC, all appellate rights must be exhausted before the Slayer statutes can be triggered. So back to you guys.
Let's talk a little bit about the property law consequences of a successful action under the Slayer statutes. Typically, the person is treated as having predeceased. The common result in most states is the person is treated as having predeceased for all purposes of any sort of property disposition. So it's going to knock you out of intestate heirship. It's going to knock you out of a beneficiary in a will. It's typically going to get rid of any survivorship interest you would have in joint tenancy, knock you out as a beneficiary under a trust, any kind of partnership or LLC beneficial interest you have, even tangible property that may be in your possession. I want to just focus for a minute on joint tenancy. One of the reasons that people often will bring a wrongful death case is because there is kind of a loophole on joint tenancy in many states. Many states limit the disinheritance of a joint property to the survivorship 1/2, regardless of who contributed the property. So if it's a spousal joint tenancy and the spouse is the killer, they may yet get to retain half of the value of the joint property, even if they didn't contribute it. So wrongful death case, you can assess damages and basically take that out through the side door and block that inheritance. And for a lot of married couples, they've got a lot of equity in a joint property. The other thing that has happened is ERISA, which requires you, if you're married, to leave any pension or profit sharing plan benefits to your spouse unless there's a notarized waiver from the spouse. There's actually a case in 2018 that ruled that, in fact, notwithstanding that federal mandate, the mandate was overridden by the state slayer statutes, so that even if the inheritance involves what would otherwise be a spousally protected interest under a federal pension plan or a profit sharing plan under 401 of the code, it still gets knocked out by the slayer statute. The important thing, I think, to take away from all this is, in addition to the complete blocking of inheriting property, very often in my experience, these cases are brought because there is no criminal conviction, there is no criminal proceeding, or the criminal case is stalled because the burden of proof is tough and the evidence isn't there. And oftentimes the heirs will try and use these cases just to kind of shake loose a criminal prosecution. And in fact, in my experience, very often there's a representative of the state's attorney sitting in the back of the courtroom watching this. And it's very hard for civil litigants to take the fifth in a civil proceeding, because there's a negative inference that arises in the civil proceeding when you take the fifth, meaning if somebody says, did you kill your spouse? And you say, I take the fifth, the civil trier of fact, the judge or the jury in that case, is entitled to assume that the answer to that question would have been yes. So there's a real overlap there between the two proceedings and the objectives that heirs and legatees have to follow. Margaret, why don't you talk about the indirect benefit and related rules?
Sure. So as Dave mentioned, the slayer is treated as predeceasing the decedent. And what does that mean for practical purposes? Well, I'll give you the very much a lawyer answer, and it depends. So for wills and trusts, predeceasing the decedent means that the next in line is going to take. That could be the descendants of the slayer or the killer, or it could be an alternative taker named in the instrument. For insurance and defined benefits plans, the plan's going to govern. So it'll be, if a next in line beneficiary is named, it'll be that named beneficiary, and if not, the plan is going to govern. Typically, it'll put some relative in as the taker. A lot of states have adopted this indirect benefit rule, which Lisa mentioned, and that is designed to bar secondary takers if that will somehow cause the killer to benefit. And this sounds like a harsh rule, but if you think about it in the context of the killer being the decedent's second spouse, and the secondary takers being that killer's descendants, but only the stepchildren of the decedent. And if those children were to take the stepchildren, then it would rob the decedent's other children blood children from taking any sort of inheritance, you can see where that outcome would weigh in favor of barring any secondary taker. So the potential for harsh outcomes, though, is really outweighed by the purpose of the rule or these statutes, which is to disincentivize killing for money. So if the secondary takers are going to confer some sort of benefit or can be seen as conferring some sort of benefit on the killer, they are going to be out too. Another thing to note is that the death attributes actually attach to the survivors. So if the next in line is a charity, the estate is going to receive a charitable deduction, even though the plan actually dictates that the assets are to pass to humans. So important thing to know when you're dealing with a taxable estate, you actually will get the benefit of that charitable deduction, even though the plan states otherwise. I think one final thing to note, and Dave touched on this just a minute ago, is that there are loopholes in the Slayer statutes. Joint tenancy is the most common, and the insanity defense is going to be another common loophole in other states. These loopholes are typically why you see wrongful death actions and Slayer statute cases filed at the same time to cover all bases. And Dave, do you have any final thoughts?
Yeah, I just want to bring people back to the estate tax issue there. Because the estate tax return has to be filed within 9 months of the date of death, or on extension 15 months, very often when there is a Slayer statute case involved, you're not going to know during that period of time who the ultimate beneficiary is, because if the Slayer statute proceeding is effective, there's going to be a change in who is the beneficiary, and that change is treated as being effective as of the date of death. So if the spouse was going to get property that will qualify for the estate tax marital deduction, and the default is going to be to non-marital parties, that would turn a non-taxable situation into a taxable situation. If humans were going to get the property, and because of the Slayer statute, it might pass on a gift over to a charity, you're going to flip from a taxable situation to a non-taxable situation. For that reason, you very often have to file on extension, and then even perhaps make a payment and a protective claim for refund if you could be moving from a taxable to a non-taxable situation. It's even more complicated if the outcome of the Slayer statute case would be that you'd be moving from a non-taxable from a taxable situation to a non-taxable, from a taxable situation to a non-taxable. As a practical matter, the IRS, I've been through this a number of times, the IRS is aware of the problem. And so if you take it up with a protective refund claim, that they're basically going to just say, call us when it's over. And they're pretty good about it. I think the one time you find some sympathy with the tax collector is when there's one of these awful cases involved. The last thing I would say is the coordination between, Lisa's correct, the coordination between state criminal proceedings and the Slayer statute proceedings is very complicated. It differs state to state. And you have to look at it. In some states, you can't even begin the civil proceeding until the criminal proceeding has either run its course or the state's attorney gives you a pass. So it's important to check with the prosecutors before you begin one of these proceedings. And Pete, that's everything I have.
Well, thank you to all of our panelists, and thank you to all of you for joining us. Upon leaving the program, you'll automatically be directed to our event evaluation. If you wouldn't mind, excuse me, filling that out, your feedback would be appreciated, because we enjoy getting your comments to improve our programming in the future. And lastly, for those requesting CLE credit in New York, please enter Diamond 29, capital DIAMOND 29, in the event evaluation form that will be circulated today. Thank you very much, everyone.